It gives me immense pleasure to welcome you all in our special lecture series. And today's topic is Migration Governance, International Legal Provision. And today our distinguished speaker is Professor Manoj Kumar Sinha, sir. And he is the director of Indian Law Institute, New Delhi. And his areas of expertise are human rights, refugee law, international law, and international institutions, and so on. Professor Sinha has been actively engaged in these areas for over 20 years now, and during these years he has been appointed at various places of eminence, including a visiting professorship at Raoul Wallenberg Institute of Humanitarian Law, Sweden, and he has also co-authored and edited several books of importance in these subjects. So let's welcome our eminent speaker, Professor Sinha. A very warm welcome to you at the GRFDT platform. And the mic is now over to you.
Thank you very much, Dr. Smita. May I know how many minutes I have to speak? So accordingly, I'll proceed.
I think, sir, 1 hour.
1
Sir,
hour.
50 minutes to 1 hour. Yes, sir. And after that, we will have 1 hour of question answer session.
1 hour question. Very good.
Yes. Sir.
Okay. Thank you. No problem. Don't worry.
Yes. Thank you so much, sir.
All right. The topic which I'm going to speak to all of you on the migration, and it's more on international legal perspective. Let me start with the first thing, and that will help us to understand migration is permissible under the domestic law and international law both. If I take you to the starting point with the Indian Constitution, and that is Article 19, paragraph D, which says we all have a right to move freely throughout the territory of India, and also subsequent rights, it says, to reside and settle in any part of the territory of India. So Indian citizens can also so migration is possible within a sovereign state and also internationally. So our concern is more on internationally, on the movement of people in search of job, in search of study, in search of anything. However, there is a overlapping, like what we have been witnessing in India. So migration in one sense lawfully permissible, both domestically and internationally. But we see illegal migration that will take later on. Uh, Most important concern, the treatment to the migrants people, those who moved from this country of origin to the another country, the migrant workers, migrant peoples, they have also all human rights. All human rights are available to the migrant population in a new country, and that can be understand. The referring point we can take with the Article 1 of the Universal Declaration of Human Rights. Article 1 of the Universal Declaration of Human Rights, which clearly says all human beings are born free and equal in dignity and rights. All human beings are born free and equal in dignity and rights without distinction of any kind. So so wherever we are, we should despite our nationality, despite of our originality, nationality and other aspects, individual has to be treated with dignity, with respect, and all human rights are available to the person. So all human rights are available to the national as well as national, of course, national as well as the non-national. In some cases, we witness there are some occasions where some kind of distinction is permissible. So even if Article 19, if I take into the discuss about the Article 19 of the Indian Constitution, it applies to the only citizens. Citizen has a right. So there is some kind of discrimination under the Article 19 of the Indian Constitution, but Article 14, Article 21, Article 25. So number of the rights under the Indian Constitution also available to the non-citizens. So so states should not discriminate on the ground of nationality, irrespective of the fact how that person has entered in the Indian territory. So he or she has certain human rights which are available to. So we see that, like, protection of the non-citizen, legally or illegally, must be treated with dignity. We must be respected their all human rights, and even in case if they have done something wrong, due process of law has to be followed. That principle, if it applies, things are perfectly fine. But what we see, there is a distinction, there is a preference between the local persons and also in the outsider. If a person who has been recruited on the basis of all valid documents, entered in the third country, and then he start facing discrimination in the health services, discrimination in education, discrimination in employment, and all a number of other areas will find. To take this particular entire aspect is become a global concern, not today. It was a global concern for a long time. And finally, on 18 days. So one main instrument today, if we see, one main exclusive instrument dealing with the protection of migrant workers or their family members, that we come to the International Convention on the Protection of the International Convention on the Protection of the Rights of all migrant workers and members of their families. So international community on 18 December 1990, on 18 December 1990, adopted a international convention on the protection of the rights of all migrant workers and members of their families. So when we look into, so this was adopted in the 1990, so almost 20 decades, 2 decades, this convention has been there. At today, we have 55 states are parties. Not a large number of states have signed this particular treaty. India is also not party of this particular treaty. With this particular treaty, which entered on the 1st July 2003. So it was signed in, you can understand. So this treaty was signed adopted in 1990, but entered into force on 1st July 2003. So you see how the states are responding towards this particular treaty. This treaty, which was adopted in 1990, actually entered into force after 13 years. It took almost 13 years to come into effect. So migration is not in a big priority, or states have very conservative view to become part of any kind of international regime on the international to which regulates the migrant workers. And what we see, and that is the reflection when we go back and look into the International Convention on the Migrant Protection of the Migrant Workers, what we witness, what we see, the response of the international community, the response of the state in ratifying. So this treaty took almost 13 long years to come into force. And today, like after completion of almost 20 years, to today we are in January 21. So completion of 20 years, we only handful of states become party to the International Convention on the Migrant Workers. In short, we can call Convention on Migrant Workers. So Convention on Migrant Workers entered into force on 2003. So it seems that migrant issues state wants to resolve. State wants, so state, why it is so, like, states are reluctant. So migrant issues, state wants to resolve on its own way. They don't want to become a party of international legal regimes which put some kind of conditions on them. And of course, we'll go back and we see that what are the important provisions, what are the protection to the migrant workers, what types of the migrant workers, and is there any kind of monitoring body available under the International Convention on Migrant Workers. So and so that we see in then another, what we see, the recent development, which has, I'm sure that some of you are aware, that United Nations General Assembly adopted, that is the Global Compact for Safe, Orderly and Regular Migration. There is also New York Global Compact on Refugees, and this is the another one international instrument, some way, Global Compact for Safe, Orderly and Regular Migration, which was adopted on 13 July 2018. So on 13 July 2018, but this Global Compact for safe, orderly, and regular migration is a soft documents. It's not like hard documents, or it's not legally binding. It's some kind of uh, uh, soft obligation on the state, and the state has to take note of this instrument, and and accordingly they can apply. They can, so there is no accountability under this global compact. However, it has been a large number of states, because this instrument was adopted by the United Nations General Assembly. Almost 193 states, almost everyone was present. So some kind of a global commitment, global commitment towards the adoption of global compact for the safe, orderly, and regular migration. In addition to that, so what we see, we have international convention which was adopted in 1990. Then we have in the 2018, we see global compact for safe, orderly, and regular migration. And then also the subject was always considered a very important subject under the human rights bodies. So human rights has always considered this subject as very important, and due recognition and due importance has been given under the international treaties regarding the to deal with the migrant workers. So what we see, the Office of the High Commissioner for Human Rights, Office of the High Commissioner for Human Rights, uh, prior to the Human Rights Council, earlier the Commission on Human Rights was there in the place. And Commission on Human Rights had two broad mandate along with other mandates, thematic mandate and also the country visit. So under thematic mandate, they appointed a special rapporteur on migrant workers. So a special rapporteur has been working under the mandate, was working under the mandate of Commission on Human Rights. Now he works under the mandate of the Human Rights Council. So what we see, we have multiple of instruments. So I'm just focusing currently on the human rights instruments. In the human rights instrument, what we have come across with the Convention on Migrant Workers. We have come across with the Global Compact Principles, and also a special rapporteur who is responsible for looking into the migrant workers and in time to time making a recommendation. So internationally, we have these three instruments are there. The fourth one is also very important, which puts state, particularly states, in a or it compels a state to respect international human rights treaties, and that is achieved, or that is done by the Human Rights Council under its universal periodic review mechanism. So what we see, the third one, the last one, where in Human Rights Council can also have some say through the universal periodic review. So universal periodic review is a mechanism under the Human Rights Council where each state has to submit a national report. Every 4 years, they have to submit a national report to the Human Rights Council, and that report should not be only one area. That report is very comprehensive. It covers all aspects of the human rights. So it says the basis of Universal Declaration of Human Rights, states parties to the various human rights. So the basis of preparation of the report is very comprehensive. So it takes care of the all aspects, and I'm sure that members keep on asking about refugee issue, human rights issues, and other. So this is the way, the framework, with global framework. When we look into the global framework, we have come across number of strong instruments available at the international level for the protection of the rights of the migrant workers and their family members. We'll go one by one subsequently. In addition to that, what we also witnessed, that recently under the uh, Sustainable Development Goals 10.7 also focuses on issues of migration, and that has been, the Global Compact Sustainable Development Goals 10.7, that also talks about the cooperation to facilitate safe, orderly, and regular migration, and it focuses on number of points. And what are the number of points are there? The first, it emphasizes on international cooperation on the governance of international migration. So this is actually a part of the global compact, which says that support of international cooperation on the governance of international migration. Then it also emphasizes on to provide of options for states from which they can select quality options to address some of the pressing issues of uh, international migration. In addition to that, what are the important areas which need to be addressed by the globally, and that has been also expressed under various international fora, is the first is the protect the safety, dignity, and human rights and fundamental freedoms of all migrants. The first is the protect the safety, dignity, and human rights and fundamental freedoms of all migrants, regardless of their migratory status at all time. So if we focus on this particular thing, so receiving state has a responsibility. Receiving state or host state has a responsibility to protect the safety, dignity, and human rights and fundamental freedoms of all migrants, regardless of their migratory status, how they have reached, what kind of, whether legal, illegal, but the basic rights of the each individual has to be respected, and that has to be in all time. It cannot be you cannot, state cannot be selective. Then of course, people can be deported, people can be expelled, but those are the different issues. But when you receive someone, you have to treat them with dignity. Even the rights can be curtailed, but all the other safeguards should be available to them. Second, uh, there's a need to support a country. So today, why a large number of states have decided not to become party of the party to the International Convention on Migrant Workers, if you look into that, it's basically on the burden sharing. So migrant workers, lawfully or unlawfully, in the large scale, when people are moving. So there is when people are moving, so maybe it will be because of the proximity, people will go to the another state, which is close, which is easy to cross. So there is a possibility of movement of people to save their life for various reasons cross the international border. This particular aspect we'll discuss a little bit later. So the country which receives or hosts a large number of refugees or migrant workers, that is a country which hosts a large number of refugee and migrant workers, they need desperately support from the international community. So migratory populations and refugees, they cannot be addressed adequately, or their needs cannot be taken care of alone by a receiving state. So what is important, which we have also seen under the refugee law, under the in the migrant in the context of migrant workers or migration, there is a burden sharing. That burden has to be shared by the other states. So the states which receives refugees and migrants, they must be supported by the international community, must be supported by the independent other states. That is the very important aspect. So if that kind of approach is followed, so things will be much easier. So what we see, supporting of the refugees and migrant workers. The third point, integrate migrants in the local population, integration of the migrant population and addressing their needs and capacities, as well as those of receiving communities in humanitarian and development assistance. So once you take that migrant populations, you have like the efforts by the state how to integrate them in the local system, how to integrate them, how to make them independent. All these aspects are very important when we look into the in the context of the migrants populations. So what we see when we go back and analyze, we see there are three important, without going into the any international instruments or any other documents, which we can highlight easily by saying that first is protect the safety, dignity, and human rights and fundamental freedoms of all migrant workers, regardless of their status, how they have entered. And this has to be all times, at all times. Then support, then second, there is an obligation. There is an obligation on the other states to support countries which has received a large number of refugees or migrant workers. And third, which we see, integrate the migrant workers is there. So these are the important aspects which, if you done, it has the issues governance, migrant migration governance will be effective. Uh, if I take you, we go back to the Universal Declaration of Human Rights for the time being. When we talk about the Universal Declaration of Human Rights, and I started with my talk on emphasizing the Article 1 of the Universal Declaration of Human Rights. And there we have realized that Article 1 has a broader implication. Article 1 of the Universal Declaration of Human Rights has a broader obligation. And then it says clearly, all human beings are born free and equal in dignity and rights without distinction of any kind. So Article 1 is very wide. So it doesn't make any distinction whether the refugees or something. So human rights is available to all. In addition to Article 1, there are three articles which are very important, which important for the migrant workers, important for the asylum seekers and others. So what we see, Article 13 of the Universal Declaration. So Article 13, 14 and 15. These three articles are very important for the refugees, for the asylum seekers and migrant workers, and it has to be applied equally to all, in whether it's asylum seekers, whether it's migrant workers, or it's a refugees. So what Article 13 of the Universal Declaration of Human Rights states, Article 13 of the Universal Declaration of Human Rights has two paragraphs, paragraph 1 and paragraph 2. The paragraph 1 of the Article 13 says everyone has the right to seek and to enjoy in other everyone has the right of freedom, everyone has the right to freedom of movement and residence within the borders of each state. So if I look into the Article 13(1), then it's more or less what we have under the Article 19(1)(d) or E. So what it says, everyone has the right to freedom of movement and residence within the borders of each state. So like the people can move freely within a country, migrate from one state. So like even the federal structure, like in our system, people from one state to the another state, and that is also reflected under the Article 13 paragraph 1 of the Universal Declaration of Human Rights, which is clearly stated under the Indian Constitution under 19D and 19E, which speaks about movement of the people. Then it says the 13.2 becomes more important. 13 paragraph 2 has it has bigger relevance when we talk about the international. So it has two components. One, it talks about the domestic sense, and other it talks about the international sense. So when we look into the international sense, we see that Article 13 paragraph 2 becomes very relevant in our context. So Article 13.2, you don't need to go to the International Convention on Migrant Workers of 1990. We don't need to go to the Global Compact. We don't need to go to the Human Rights Council. We don't need to look in any instruments or International Organization of Migration, the body which takes care of the migrant issues more comprehensively, that we don't need to go anywhere. So we have a human rights instrument recognizes much earlier in 1948, 10 December 1948. That's clearly states that people can move. And what it says, everyone has the right to leave any country. Everyone has the right to leave any country, including his own. Everyone has the right to leave any country, including his own, and return to his country. So we all have a right to migrate and also to return whenever we want, for in search of job, in search of education, in search of anything. So we can all can migrate. So migration in some way is strongly incorporated under the human rights instrument, that is Universal Declaration of Human Rights. Not only Universal Declaration of Human Rights and the other human rights instruments, starting with the International Covenant, which I'll take you later. But when we look into the Universal Declaration of Human Rights of the 1948, without looking into any support, we can say, and because Universal Declaration of Human Rights has become today part of customary international law, so this is very binding. So people have a right to leave their country and return to their country. So why you leave your country? You leave your country in search of a job to the Gulf or any other places to for the better, for the job purposes, for the education purpose, or it may be any regions. You can do that. Then you go to the next one. So 13 means it permits. So human rights instrument in some way allows people to go out of the country and return back to the country. The next one is the Article 14. And there we see some kind of linkage between the migrant and also onto the refugees, like, So Article 14, when we talk about the refugees, because you'll see that refugees and migrants is a little bit like overlapping, or internally displaced person we'll look into little bit later, but we see that refugee was refugee has a separate instrument, international instrument, 1951 convention and 1967 protocol. For the time we will let it be there, we will come back and touch 1951 convention and 1967 protocol little bit later. So when we look into the Article 14 of the Human Rights, Universal Declaration of Human Rights, after 13, it says everyone has the right to seek and to enjoy in other countries asylum from persecution. Asylum from persecution. So that is very important. So everyone has the right to seek and to enjoy in other countries asylum from persecution. Means it's some kind of condition has been imposed. So people can move to the another country if people or individual has a fear of persecution. So we see, so it's a beginning of getting refugee status in a particular country. So people have a right, every individual has a right to leave his country and seek asylum from persecution. It doesn't say that. A lot of critics of the Article 14, they say, right to asylum is guaranteed. So receiving state has to go. They can seek, but there is no guarantee. It's a receiving state has to grant final status. So that is the confusion a little bit. But as a human rights instrument, it says from persecution. And when you talk about the persecution, and we go to the 1951 Convention on the Status of Refugees, what it says in the Article 1A of the 1951 Convention, it clearly states a person who has well-founded fear of being persecuted. So Article 1951, so you see that similarities between the Article 14.1 and 1951 Convention. So Article 51, Article 1 of the 1951 Convention on the United Nations Status of Refugee, it says, it defines who are refugees. So it says, so that is the distinction you can find out. So it says who are refugees. So according to the 1951 Convention, it says a person who has well-founded fear of being persecuted. A person who has well-founded fear of being persecuted on the grounds of race, religion, nationality, political opinion, and membership of a particular social group. So there are 5 grounds is given. A person who has well-founded fear of being persecuted on the grounds of race, religion, nationality, political opinion, and membership of a particular social group, and have crossed international border. So in both situations, you have crossed. So you international have crossed international border are entitled for the asylum and then subsequently and the refugees. So what is there in the so the three conditions are there under the 1951 convention: persecution, second grounds, and third crossing of international border. The crossing of a, so if you examine, if you analyze the Article 1 of the 1951 Convention, what we gather, there are three important criteria which needs to be looked into, which needs to be satisfied. The first, a person has well-founded fear of being persecuted, persecution on the ground. So grounds has to be five. So five grounds, what I have mentioned: nationality, political opinion, social group, nationality, political opinion, social group, membership of a particular social group, race, religion, nationality, political opinion, and membership of a particular social group. The last point also important: you cross international border. So you have, if you have fear of persecution, you have a right to seek asylum under Article 14 of the Universal Declaration of Human Rights and Article 1 of the 1951 Convention, and receiving state has an obligation. So if you manage to enter in the India, or if you manage to enter in the United Kingdom, they have a right because you have a fear of persecution. So you become initially asylum seeker. So your status will be determined later. You are not refugee. You have a fear of persecution. So you put your claim, and then UNHCR, and depending upon the system available in the country, your status will be determined. So refugee status determination test. So that is called in the UNHCR wording, refugee status determination test, RSDT, that is there. So refugee status determination test. So if that you qualify, you may get refugee status, or you may not get a refugee status depending upon the your case. That is there. But Article 14 has, and that is the exception. So quickly, I'll just see Article 15, which also says who are not entitled, means exclusion. So definition, who are entitled to become refugee and who are excluded from the definition. Similarly, Article 14 of the Universal Declaration of Human Rights as well talks about the who are excluded, who are not entitled to, who are not eligible to become become asylum seeker. And it says Article 14 paragraph 2, this right may not be invoked. This right may not be invoked in the case of prosecutions genuinely arising from non-political crimes or from acts contrary to the purposes and principles of the United Nations. So if somebody has done crimes, serious crime committed, or something done contrary to the purposes and principles, they are not entitled to enjoy the benefit or invoke the Article 14.1, Article 14.1 of the Universal Declaration of Human Rights. There is also similar criteria mentioned under the Article 1F of the 1951 Convention, which talks about the exclusion clause. So who are excluded, that is there under the 1950. So if we look into that, Article 13 also permits, Article 14 a specific grounds it mentions, but Article 13 says people have a right to move freely. Article 14 puts you have a right to seek asylum, enjoy asylum, if you are persecuted or you have a fear of persecution. And then finally, the last, which is equally important, the nationality. Everyone has the right to a nationality. That is very important. And it says, and Article 15.2. So Article 15.1 says everyone has the right to a nationality, and Article 15.2 says no one shall be arbitrarily deprived of his nationality, nor denied the right to change his nationality. If these three articles under the human rights instrument throw much bigger light when we talk about the refugees, when we talk about the migrant workers, and when we talk about the internally displaced persons. So last point, which like, I'll just take 1 or 2 minutes here and then we move to the next aspect. When we took like in this entire situation in the refugees, what we have learned today, when we discussed about the refugees, I'm sure we got an idea what are the conditions which needs to be satisfied. In the migration, it's lawful. Simply you apply if you can go and where people are moving, and you will see that how many people are moving around the world. But in refugees, what is important? Crossing of international border. Just imagine those who fail to cross international border. Those who cross to fail international border, but they have a fear of persecution. They are persecuted because of religious belief in their own country. But they could not cross international border. They failed to cross international border, or they chose not to cross international border, live within the country, and see safe haven or safe place within the country. They in search of the country. So they moved from one place to the another place. They moved out from their habitual residence. They have moved out from the habitual residence because of fear of persecution. But they decided, or they did not get an opportunity to cross international border. They remained in the same state which is persecuting them. In such a situation, those people are not getting benefit of the 1951 convention, because the last condition of the 1951 convention, which says crossing international border, since they could not cross international border, they remain in the country. They take the benefits of the human rights instrument, constitutional guarantee. So whatever the laws available to they have available to them, the same laws are there to protect them. So human rights instrument comes into. But these kind of people are known as internally displaced persons. So there is a distinction between the refugees, between the internally displaced persons. So internally displaced. So these people are called as a internally displaced person. So you have to keep in the mind internally displaced persons. Situations are similar. Situations are similar is there. Let me just give you some facts of the international organization for migration, which is the body IOM, which takes care of the entire migration issues, works in the migration field extensively. And according to their report, annual report of 2020, so their annual report, which I looked into the study night, and that's a very detailed how many people are refugees worldwide, how many internally displaced persons are there, and how many people are migrating. At present, the number of international migrants is estimated to almost 272 million. 272 million, according to their report, 272 million globally. And so 272 million people migrated from one place to another. And out of this entire population, nearly 2/3 being labor migrants. So 272 million, and out of two-third populations are labor, working for the carpenter, mason, and some kind of construction site, carpenter, or other things. So two-third populations of 272 millions are actually labor migrants. So total number of migration population comes out, total implication of the labor migration comes out, if world population we see, it's only 3.5 or 6. So it's not even 4%. So total population. So what it gives a message, actually people are not keen to leave their own country. People want to live wherever they are there. People are not moving. So the huge population, and even this population, people are for economic reasons, because the populations we have out of 272 millions, what we see, that is the only less than 4% of the world population, and among them, two-thirds populations are labor population for economic reasons. They are just in search of maybe Gulf and other places, or they are there. Interesting fact which we have, India had the largest number of migrants living abroad. So in the world, we are the largest. India had the largest number of migrants living abroad, and that comes around 17.5 million. So 17.5 millions are living across the number of countries in the world. So that is the highest. So we are the highest contributor. India is the highest contributor. India's populations living abroad is as migrant workers is around 17.5 million, followed by Mexico and China. Mexico has 11.8 and 10.7 million respectively. So Mexico is the second highest and China is the third is there. Top destination country for the migrant workers, for the that is the USA. Top destination country, and almost 50 million populations are migrant population in the United States. So top destination country is the USA. When we look into the global refugee population, what we come across, it has 25.9 million. So global refugee population has come down. Over the years, refugee population has come down for various reasons, because that we'll discuss that one. Global refugee population at present, 25.9 million. And internally displaced persons. So what we are seeing of late, starting from the late end of the 20th century and beginning of the 21st centuries, in the increase of internally displaced persons worldwide. So populations of internally displaced persons today, it's around 41.3 million. 41.3 million populations are worldwide internally displaced person, and this internally displaced person is largely contributed due to the conflict happening in large number of countries in Africa and some countries in Asia, and also in some Latin American countries. Due to conflict, due to ethnic conflict, religious conflict, or other reasons, what we see, people are moving from in search of safety and security. They move from one place to the another place. And that is the reason it has contributed. So today we have more number of internally displaced person in the world compared to the refugee population, which is coming down and which has come down to the 25.9 million. The last category which we have is the stateless persons. Stateless persons, that is also a huge number. It's not a stateless person, a person who is not recognized by any nation. There's no document. So sometimes we never realize the importance of nationality, or say so we have a passport, we feel very, so a large number of people is no state. There's no, legally they are recognized. So their number is equally 3.9 million is there on the world. So what we see that overall population is the migrant population is high, and but migrants is not so conditions for the stateless, condition for the refugees, and conditions for the IDPs are entirely different. Entirely different. We don't need to compare with the migrant workers. Migrant workers, they go into the search of the job, and we'll see also the types of migrant workers in a couple of minutes in there. When you look into any instruments, including the Convention on Migrant Workers, let me just throw some light on the Convention on Migrant Workers, and then we'll close there. Even in the preamble of the Convention on Migrant Workers, we look into the preamble of the Convention on Migrant Workers, what it says, so this convention is adopted for the protection of the rights of the all migrant workers. So it identifies what are the rights of the migrant workers. So whether migrant workers have a rights are different to the local population or citizen of that particular country, or more or less they have same right, like right to housing, right to food, right to security, right to job, right to equal wages. Whether these rights are same to the migrant workers, or it's a different from the local population where they have gone there. So that is the important point. If that practices is going on, then it's like no discriminatory practices will be there. But when we look into the entire efforts of the members who drafted, involved in the drafting of the Convention on Migrant Workers, they tried to identify, and if you remember when we discussed, all human rights are available to the migrant workers. But a specific convention was adopted in 1990, which says protection of the rights of all migrant workers and members of their families. And when we look into this preamble of the Convention on Migrant Workers, it says it takes taking into account the principles embodied in the basic instruments of the United Nations concerning human rights. So United Nations concerning human rights, in particularly the Universal Declaration of Human Rights. So we discussed Universal Declaration of Human Rights. Then it talks about the International Covenant on Economic, Social and Cultural Rights, International Covenant on Civil and Political Rights, Racial Discrimination Convention, CEDAW rights of the child. So what we see, so not only Migrant Workers Convention, it becomes ICCPR important for them. ICCPR talks about civil and political rights. ICESCR talks about the economic and social and cultural rights. So in a nutshell, economic, social and cultural rights is talk about the social security. It talks about the right to work. It talks about the right to adequate standard of living. It talks about the right to health, and it talks about the right to education. So means these. So when in the preamble it mentions about the civil and political rights and economic, social and cultural rights. So one thing you have to understand, that Convention on Migrant Workers also recognizes, of course in a different way, recognizes within itself in this instrument the civil and political rights, economic, social and cultural rights available to the migrant workers as well. So it allows, so like, what is there under the, so if a state is not party of the, like if India is not party of the Convention on Migrant Workers, we can't get away, because we are party of the International Covenant on Civil and Political Rights. We are party of the International Covenant on Economic, Social and Cultural Rights, CEDAW and CRC. So if you see all these instruments, migrant workers are protected, even in India, because in the preamble itself is there, Universal Declaration of Human Rights. It also talks about the charter. So charter also, United Nations Charter, that is very important, where the role of the each state become very important and fundamental in the protection of the rights of the migrant workers. When we look into the United, so purposes and principles of the United Nations Charter become very important. And when we look into the United Nations Charter, and it says clearly under Article 1, paragraph 3, if you remember, in our discussion, it figured out cooperation. Cooperation becomes very important. International cooperation becomes very important. And then when we look into that, and that it says, I'll just take only one article under the United Nations Charter, that is Article 1, paragraph 3. Out of 4 purposes, there is Article 1, paragraph 3 of the United Nations Charter that becomes very relevant and important in today's context. So what it says, to achieve international cooperation in solving international problems. So Article 1, paragraph 3 of the United Nations Charter, it clearly states to achieve international cooperation in solving international problems of an economic, social, cultural, or humanitarian character. So like, whatever nature, economic, social, cultural, or humanitarian character. So what is member states to work together? They should work to help each other to resolve any problem related with the economic, social, cultural, or humanitarian character. It goes further. The Article 1, paragraph 3, it talks about in the first stage about the international cooperation to resolve the problems related, economic problem, social problem, cultural problem, or humanitarian character. So migrant workers can be also humanitarian problem is there. And it goes further and it says, and in promoting and encouraging respect for human rights and fundamental freedoms for all without distinction as to race, sex, language, and religion. So it emphasizes the Article 1, Paragraph 3 of the of the United Nations Charter. Uh, it talks about international cooperation, and it also emphasizes on the aspect of non-principle of non-discrimination. Now come to the quickly to the International Convention on Migrant Workers. So what we see, the protection or identification of the rights of the migrant workers is also acknowledges, it also recognizes the various human rights instruments, including UDHR, ICCPR, ICER, CEDAW, and CRC. If these instruments are there, they try to take and try to convince that these rights are also available to the migrant workers. Go to the Migrant Worker Convention, and it says, so when we look into the convention part, under Article 2 of the convention, it talks about the migrant workers, and it refers different category of the migrant workers: frontier workers, signal workers, seafarer, outker, itinerant. Then it goes into projectile specific. So it defines. So Article 2 of the Convention on Migrant Workers is mentioned there. But most important part is there, the persons, Article 3, which talks about the present convention shall not apply to. So convention migrant workers shall not apply to if a person is employed in international organization, if somebody is working in international organization and agencies, or employed by a state outside the territory to perform, so like ambassador, they are not migrant workers, they are representative of the states. So persons taking up residence in a state different, refugee and stateless person. So refugees and stateless person cannot be also excluded under Article 3 of the there. And then student trainees, they are not migrant workers. Then it's most important, which is important. It talks about the non-discrimination principle, and that is very fundamental in when we discuss in the human rights case also. It talks about state parties in accordance with international instruments concerning human rights to respect and to ensure all migrant workers and members of their families within their territory are subject to their jurisdiction without distinction of any kind, color, race, religion. So what we see, the non-discrimination principle is also very fundamental under the Convention on Migrant Workers. So states shall not discriminate. So receiving state or host state where persons are working, they should not be discriminated on the ground of race, sex, language, religion, or conviction on political is there. Now the human rights, that is the that is detailed. So basically, when we look into human rights of all migrant workers and members of their families, it's more or less civil and political rights and economic, social, and cultural rights in detail. It has given under the convention. So I don't need to go and repeat what is the migrant workers and what are the rights to the migrant workers. In nutshell, we can say the rights which are available to the human being. All civil and political rights, economic, social, and cultural rights are available to the migrant workers. And it talks about the social security, enjoyment, everything is there. And finally, what is important, this Convention on Migrant Workers, it has a monitoring body, Committee on Migrant Workers, a Committee on Migrant Workers, which is the monitoring body available under this Convention on Migrant Workers. And there, the committee has a responsibility to see that a state party, if state is party to the Convention on Migrant Workers, they implement the convention. They have modified their law according to the Convention on Migrant Workers, and see that the states are implementing the rights mentioned under the Convention on Migrant Workers. To establish the relationship between the monitoring body, so monitoring body which is known as a Convention on Migrant Workers in the 1970 in the 1990 convention, and state, there's one obligation which is compulsory, which each state has to perform, and that is under Article 73 of the Convention on Migrant Workers. that is the state has to submit a state party report. Is like state will every time how they are implementing the convention on migrant workers in their own territory, and how it is implemented. That state has to submit a report to the committee on migrant workers, and committee on migrant workers will agree whether there's the committee can make a comments migrant work convention has not been implemented properly, or whatever issues are there that can be taken care. Unfortunately, the only convention and subsequent efforts, what we see, the only instrument which was adopted at a global level. So if you ask me to say that international legal framework for the protection of the rights of the migrant workers, so I will say the protection of migrants. So there is only exclusive instrument, lax specialist, is the Convention on Migrant Workers of 1990. So that is a legally binding. However, we also have noted that global compact principles, which has come recently in 2018, then we have also the role of the International Organization of Migrant Workers, some way role of the UNHCR and other bodies also we see. So global compact which has come, it's more like, basically as a soft law. So what we see, the only exclusive instrument is the Convention on Migrant Workers. And we can also conclude by saying that all rights, all civil and political rights. So once a migrant worker, suppose we move from India to Australia, or for New Zealand for any purpose, and remain as a migrant workers, take a job, not as a nationality, we work for the time. So all the rights which are available to that country's people are available, more or less available to the foreign national as well. So state has an obligation to respect the rights of the migrant workers, give them similar treatment, particularly in their family members, in field of the education, in field of the health facilities, in field of the social security, in field of the pension scheme. So that is there. But what we see, those who are qualified, those who are educated, they are more protected. But the figure which we have located, from the annual report of the International Organization of Migrant Workers, what we see, that two-thirds population of the migrant workers are labor class, particularly for the labor sector they are doing. And there we see these rights are, there are a lot of issues, there are a lot of aspects are there, and cases of violation of their rights are rampant, in particularly in number of countries, in Asian countries, we keep on noticing. So I feel if states, receiving state, take note of the 1951 convention, take note of the human rights instrument, I'm sure that governance of the migrant population will be more effective, and their rights will be protected. They may not feel discriminated, and a large number of people will also tend to move from one country to another country at the international level. So time has come to strengthen, time has come to ask our own country to become the party of not only to the Convention on Migrant Workers, but also to the 1951 Convention, and particularly in the South Asian context, what we see, the South Asian context, none of the countries are party of the 1951 conventions are there. And of course, there are specific conventions are there, which some gentleman is mentioned. The International Labour Organization also exclusively deals with that particular thing. That ILO conventions are also relevant, which state is party. But somehow ILO convention never acquired the strong strength by the state. Hardly we neither in academic purposes. We have ILO conventions, no doubt about that, more than 200, but it hardly figures in official discourse, it hardly figures in the academic discourse, and even in the court. You even the local jurisdiction, ILO conventions are not, unfortunately, is not taken so seriously. That is the major issue on that particular time in the ILO convention. With this, I end here, and would like to thank Dr. Ismita and all the organizer for giving me a time to share my thought on the governance on the migration.
Thank you very much, sir, for this really valuable talk and lecture. And I look forward for a very constructive discussion ahead. I see there are a lot of questions in the chat box.
Yeah, a lot of course.
Yeah, sir, you would like to, you might have seen and you'd like to answer any of them or some of them or all of them? Or
Hmm?
would you prefer to answer the questions we are already in chat box, or you like to take it in person, I mean, whatever you are comfortable with?
No, I think just I can do one by one. There's no problem. I'll take, if you suggest me, I can go to the chat box and I
Or
already am there. And I think the first question, no, there are, I start with the beginning. Just a sec.
yeah.
Om Prakash Manji. There are a lot of great points there, Professor.
Sir, if you suggest,
Acha,
and
all right. So let me start with the Om Prakash question. What are the basic difference between migrants and refugees? I think Om Prakash, I have made an answer for the basic difference from the migrant. So migrant can be like lawful people can go, and also the uh, also we have seen uh, it can you take obtain a visa, you go for a work, and you can become a migrant worker. It's not a big issue. But refugees, you have a certain condition which I have mentioned to become a refugee. So there's persecution is important in a migrant worker. So there may be possibility if you have a fear of persecution, you can become refugees. For migrants, you don't need to be a persecuted. You can, it's a voluntary, it's your own choice, you can go. But even a number of cases where people are in search of economic regions, we across the border, we find a lot of problem. And what is going on in India in number of provinces, we see that they say they are migrant workers, they are illegal migrants, they have entered in India and they acquire the citizenship. So those issue I don't want to go, but if you look into the clear definition for the refugees, uh, persecution is very important, and crossing international border. Migrant cannot, not necessarily has to cross international border. They can cross international border, and they can also, we are also migrant. So from one particular state, we move to Delhi and we are working there. Uh, then why international Thampi Nagarjun, which international law allows, then why big walls? That is the unfortunate part when it comes to the, if you look into the international law or any kind of public discourse also, but when it comes to the accepting migrant lawful migrant workers also, there are a lot of conditions are imposed. Borders are regulated. Borders are heavily regulated these days, and flow of the movement of the people have been restricted. And not only internationally, also there are a lot of regional mechanism has been evolved, like Schengen treaties and others, European Union. So this kind of practice is there, and what we preach, what we discuss in the international law, when we look into the application, we find there is a huge gap. There's no denial. So there is where states become very particular, even including India. So and they may have their own regions. So I find that is there is a problem. Then discrimination with refugees in various countries and international and human rights should not have talked. Let me, Om Prakash, another question. Discrimination with refugees in various countries, international and human rights should not have talked. Refugee could be obtained citizenship in any country. Refugees could be discrimination is there between the treatment of the refugees and also between the local citizen. No doubt that is the major problem refugee faces everywhere, whether it's an European country or whether it's in a Asian country. Discrimination between the local population and refugee population. Getting citizenship is very hard. It's not so easy. It takes a lot of time, and it depends. Uh, and in India, it's like will be difficult, and the other countries equally difficult. So citizenship is an issue. But refugee, if refugee become like when we talk about the refugees, it also we talk about the durable solution. Durable solutions means one of the durable solution, local integration. Local integration person has been taken the nationality of that particular country. So the law talks about, it says ki durable solution, to help the refugees we have to find out a durable solution, and under the durable solution, one of the solution, taking the citizenship. But citizenship remains a big issue. It is decided according to the citizenship law of that particular country, and other conditions laid down by that particular government regarding the refugees. So they both have to be looked into. Global estimate of international migrant, not by the IM. The ILO has estimate. No, like no, I PS3 study I have seen, and this I have taken from what I have mentioned, the annual report. I'm not saying ILO. There, this report is there, annual report 2020. So you kindly look into the IOMO side, and you will find the details. So yesterday I have looked into the international migrant population in the International Organization of Migration, and so that the IOM World Migration Report has quoted these figures. So I have mentioned, yeah, you also mentioned the IOM World Migration has quoted these figures. All right, so there is some kind of, we move to the next question. Adomi Adok's question is, mention the political implications for not respecting of international law and rights of migration across the world. I don't see political implication. Political is like political, due to the political implication at the national level, the rights of the migrant workers, rights of the refugees are like denied, because there is a link. So it more governs in the domestic politics. So domestic politics play very important. So political implications are negative. If a party is become open hand, like party become very liberal, a government become very liberal and admit liberally migrant population, give them cities. Migrant population is not issue for the refugees. I sure that a large number of local population will not be happy, and that is the reason conflict keep on happening in the other parts of the day. Uh, International law are not being promulgated in matter of refugee. What are the problem behind? This basically it's a domestic consideration, and sometimes I feel in Indian context is more with the local regions. Various factors are there, and if I give you an example of India, the government, states government keeps on mentioning that our we protect refugees, of course, not being party of the 1951 convention, not being party of the 1967 protocol, but when it comes to the protection of refugees, what we see, our track record is very good. So government of India somehow, that is some extent that is true. Not only the executive part, also judiciary has played very important role in the protection of refugees in India, without being party of 1951 convention and its protocol. So some way track record is there, but government government, so it's a more a policy matter. Government is not keen, and that is not the only problem confined to India. That is problem to the South Asian context also. So in the most of the South Asian countries are not party of the refugee convention, and this was also realized in 1994 when Sadaka Okada was the High Commissioner for the Refugees. So she realized to encourage the member states of the South Asian countries to develop some kind of regional mechanism on on themselves, which can be useful. And she encouraged, and finally in 1997, we have a model law in the refugee for the South Asian countries, which has not got due recognition, but efforts of the UNHCR was there. They encouraged a number of people from India, Justice P.N. Bhagwati, from Bangladesh, I think uh, judge, former judge of the Supreme Court was there. There are 7, 8 eminent people, so eminent people's group. So she constituted eminent people's popular, so eminent people's group to work for the local instrument or sub-regional instrument, and efforts of her. So they also realized, UNHCR also realized that these countries are not keen for various reasons. So India believed from the very beginning the convention is drafted keeping in the Western crisis. So it was not adopted, and some extent that is true. It was never adopted to resolve refugee problem globally. It was more focused to the East European countries. And that is also mentioned, and that is the reason they say, and they also realize, European countries also realize, refugees emerged in Europe largely because of the First World War and Second World War. So India argued for many times it's not a global convention, it's more on the confined to the European convention drafted by the European for their own people. So why should we adopt? And that is the argument we take. In large number of cases, we continue to have that particular feeling. It's not the global convention in a sense, and that has also accepted by the UNHCR some extent. So she tried, Sagada Ogada, she tried to convince eminent peoples in the South Asian countries to get together and work for yourself. And then finally we had a model law on refugees. You will find there are a number of articles. If you have interest, you can look into the website. There are a number of articles written on that. So, but unfortunately, even that exercise was not successful, and it remained confined to the academic exercise. How can the rights win the light of hard lockdown condition where borders are closed and migrants are not permitted to cross? How can the rights be viewed in light of hard lockdown condition? Yeah, this is even if you look into the office of the High Commissioner for the Human Rights, they have also said that because of lockdown, because of the COVID-19, migrant populations are facing a lot of problems, and particularly because they are vulnerable, women and children, not only in the crossing international borders, there are other issues are also. So of course, for last 1 year, refugees, migrant workers, displaced persons, they are facing huge problem. And I hope that when things become normal, that can be addressed. But of course, that has created a lot of problem, no doubt about that. In Gulf countries, everybody entering legally, but if the sponsor who is 100 responsible for stamping the legal visa, if not done, migrant become illegal or even treated less than migrant. Due to so many reasons where a safe birth happened, become refugees, and another unknown who we can make response. Uh, I don't think that Thampi, I will be able to give you correct answer, but maybe I'll be happy to hear from you about your specific question. So Thampi, sorry, I'll not be able to elaborate what you have asked, and I think I'll be happy to hear from you. So Babuli Nayak, then hopefully President Mayagar and vote bargaining power mass India, but only less than 4%. I think Dr. Smita. Dr. Smita, I think yes, the eternal. I cover more or less. I think our one.
Yes, yes, sir. That's perfectly fine. Just if anybody wants to ask any question in person, may raise their
That
hand.
will.
That would be better because there are a lot of discussions more than questions. It seems difficult to. Uh, uh, uh,
Yes, yes, fine.
okay. The thumb. Yes.
I would like Thampi
You
to
can
say something
unmute
because.
yourself and ask your question. Mr. Thampi, you can unmute yourself and please be brief in your question and clear. I mean, please ask direct question and it should be brief also. Thank you.
I read the Thampi's question, but I would like him to hear his view. I'll not be able to answer, but I will look forward to hear his view or her view. What
Okay, fine. Rakesh,
Yes, yes.
can we?
Hello.
Yeah, Professor, can you hear me?
Yes, yes, sir. I can hear you, sir.
Yeah, your presentation is very nice. Of course, you had a detailed information. My concern is, in Gulf countries, when the migrants are entering, 100% under the kafala or sponsorship, and the sponsorship is owned fully by the sponsors in their country. So if they are not stamping or renewing the visa, the migrant become illegal and he will be in jail. And he will be deported also as an illegal migrant. But no fine or penalty for the sponsors. That is one thing. Secondary, while on entering itself, most 95% of the sponsors used to grab and keep the passports, and there is no mechanism to prove that passport is given to the sponsor. So in that case also, the as of there is no right document, the migrant can't come out of his country. So these kinds of atrocities are too much in Gulf countries. And I am instrumental to form the first trade union in the Gulf. And on that pretext, I was also jailed for 108 days. So these are the atrocities mainly in Gulf. We are all telling Gulf is very good. Gulf is very good for migrants. Especially the people there are illegal people, domestic workers are also there. Please, I need a comment from you.
Totally agree with you, and I also expressed my inability. But however, what I suggest, like, what we gather from the newspapers and also from the Ministry of External Affairs. So this is a serious issue which government has also taken note of. But there are a lot of channels involved in this particular exercise. So whatever the safeguards government is planning, like first only recognized agents should send the people, like government recognized. So that is there. But sometimes agents or people are trapped. People are innocent people, liberal people, they are trapped within the. So some are the fortunate, at least they have landed in another Gulf country for work, and then they find there is some, they have been cheated. Then without of any fault, they they paid money, they have gone everything, but later on they found that there's something, some trick has been played by the local people in India, and so it's like great networking is there. That networking has to be broken by the effective response from the sending state, country of origin, and receiving state. If both can work, so these issues which you have identified, I'm sure the government of India is aware. Similarly, aware that there is just something fishy going on. So collaboration between both countries, how to make it effective and sure that these kind of cases can be reduced. if and that depends upon the role of the state. And I believe that sometimes also we see on the television कि ना आप क्यों बाहर जा रहे हैं, have you registered, some kind of small one capsule government of India has introduced. But I think for this and the second aspect which you have also identified, that we see in the cases of particularly in the human trafficking in the East European countries, girls are taken forcibly and their passports are taken in the England and they are forced into sexual trafficking. So much worst condition in the England, because recently I read in the magazine, lot of East European countries on the valid ground they were brought, and subsequently agent has confiscated their passport and forced them in the sex trade or something, and they are doing. So not only in the Gulf, it's a global phenomenon in a different form. In the global, it's a labor context. In the Europe or America, it's going on more on the human trafficking, where the sexual sex trafficking is happening, or sex trade is taking place. So that is a big issue which needs to be, I believe that ILO, International Organization of Migrants, and then also about the human rights bodies, United Nations also has to come together and find out. UNODC, United Nations Organization of Drugs, and they have to play important role. So these cases are keep on happening, and it's a very disturbing and huge challenge before the state. I hope that some permanent solution comes.
From my experience, what I understand, as the percentage of migrants are only meager, less than 4%, and they are not having voting power, government is not much interested in taking care, because we migrants have got no bargaining voting power. That is the reason the sending country not at all so much interested in our things, I assume.
Yes, Professor. Yes, Thampi said, what is saying, this global population, not in India 4%, it's a global population of the globally, the 4%, and we contributed. And of course, till they acquire their nationality or something, that migrant workers doesn't matter. They don't matter for them. Once they become local citizen, then they are treated nicely. But before that, there are a lot of governments are no governments. Not in India. No governments are very keen to give treat them equally with their local cities.
Thank you, sir. We'll move to our next person, Sri Lakshmi Mohanty. Sri Lakshmi Mohanty, if you're there, please unmute yourself and ask your question.
Am I audible?
Yes.
Thank you so much, sir, for your wonderful lecture. So my question is that how to define soft laws, and how can you relate soft laws to the international laws, which in the context of accountability of the state with these laws?
Soft law is towards to, so it's a first stage in one way, and to define, first I come to define distinction between the soft law and hard law. When I talk about the as per my understanding, the soft law means General Assembly resolutions, then declaration, then guiding principles. They all are soft laws. They are considered in the soft law. Now, Universal Declaration of Human Rights, when this is when it was adopted in 1948, even Eleanor Roosevelt, she was the chairperson of the drafting of the Universal Declaration of Human Rights. So she said in that, this is not a legal document. What we are making a document which only identifies human rights. So state is free. So state is free, but state has to take note of this instrument and identify and incorporate human rights in their constitution. So that time it's a non-legal, so it's a soft law. It's just a guiding. It has no mechanism for the enforcement, and there is no obligation as such. But the evaluation of the, even the Global Compact for Safe, Orderly and Regular Migration, which we discussed, adopted in the 2018 by the General Assembly. Now, General Assembly consists of 193 members. So out of 193 members, large number of members, they agreed. Means it's like, so international law functions on the good faith, on the good faith. So you have also participated, India also participated, means you have to respect these principles. So you may not be questioned because there is no accountability. There is no accountability and there is no body also to question you on that particular thing, particular aspect, even if it's a violated. So idea is to gradually move from soft law to hard law. When the preparedness is there, the state has adopted, a state has made national law on the same subject, they can later on the convention and covenant, like like if you take an example of Universal Declaration of Human Rights. So Universal Declaration, if Universal Declaration is a strong instrument at that particular time, then there was no need of adoption of International Covenant on Civil and Political Rights, International Covenant on Economic, Social and Cultural Rights. Because what are there under the ICCPR and ICSR already available in the UDHR. So soft law is in a way conveys a message to all the states. These are the things which you need to follow at the domestic level. You respect these things. What are the rights of the migrant? What are the important things? So they convey a message, and sometimes state also acknowledge. They participate. They say, we respect global compact for safe, orderly, and regular. While handling migration, we look into the global compact principles. We look into the guiding principles on internally displaced person. So it's up to the state. Soft law can also become a strong law or hard law. To conclude your question or answer, what I say as a teacher, if you teach somewhere, you can say General Assembly resolutions, then guiding principles and declarations are soft law, whereas convention, covenant are hard law. So it's a two-stage process basically. First you go slow and then second you make accountability.
Thank you, sir.
Thank you, sir. Next, from Mr. Om Prakash Manji. Manji sir, please unmute yourself and ask your question.
Can I hear me, sir?
Yes, Om Prakash ji.
Firstly, I congratulations for an informative lecture, sir, and talks about a technical issue of migration governance. And sir, you are giving my so many questions answered. One question is left. Can the migrants as well as the refugee benefited the naturalization process to get the citizenship?
Naturalization process in a country.
Yeah. Sir, my question is that can the migrants as well as the refugee benefited the naturalization process to get us citizenship, sir?
I don't see for the, if you take, so it's a choice of the both migrant workers and refugees. So first is a choice of both, whether they want to take the citizenship or naturalization process, they want to be part of there. So sometimes if I go somewhere or you go somewhere, you think, I'll work and come back after 30 years. I don't want to be so it's a choice of refugee also. So this opportunity refugee has also. Refugee, if he has been given a status of refugees, his status can be also seized. One particular time, he is no longer refugees. So अगर आप देखें होंगे ओम प्रकाश जी, तो refugee convention also talks about cessation clause, exclusion clause, and it defines refugee. It also says कि when you will be no longer refugees. So if a refugee adopts the nationality of that particular country, he is no longer refugees. The second condition, the condition which compelled him to leave his country. So suppose in 2020, something happened in his country because of his political opinion, he left because of his political opinion. And then he got, subsequently he gets protection in France. He stays there 5 years. But in 2025 election, a new party has come which supports his idea which he propagated in 2020. So situation which has compelled him is no longer in existence. Situation which compelled him is no longer existence. He has two options. He can come back to his country and he can continue with the country which he has adopted. But he will no longer be refugees because condition is not there. So his status may change, but he cannot be forced to go back. So naturalization process is much simpler. When I say about the migrant workers, so migrant means like, distinction is there. So now the Canada, USA, Australia, New Zealand, they want professionally qualified persons. So if professionally qualified persons are coming to their country, they are also considering them as an asset, human resource. So they are more willing to give them citizenship and settle down. But when it comes to the refugees, there are a lot of conditions, their background, there are a lot of things are there. So migrant, the process is smooth process for like naturalization of refugee migrant workers is easier if he is a professionally qualified compared to the unqualified or not so qualified person. Refugee little bit it takes time, but it depends upon but receiving state, they discriminate between the naturalization process between the refugees and migrant workers, but both can be accommodated.
Thank you, sir.
Thank you,
Next,
Prakash.
Sridhar and Sridhar.
Yeah. Hi, Professor. Hello. Am I audible?
Yes, Sridhar, you are audible.
Yeah. Hi. Thank you, Professor, for this wonderful insights into migration governance. One question that I wanted to ask is, could you brief about the WTO laws? Actually, they also talk a lot about the governing international migrants and how effective they are or how ineffective they are in governing migrations. I mean, this is one thing that I wanted to understand. You can unmute, Professor.
Sorry. Which law you talked about? WTO or?
Yeah, WTO talks about the international. Actually, you've been dealing with the stock of migrants. I mean, the laws that pertains to the stocks of migrants. But WTO is something which actually talks about the flow of migrants. I mean, that's like mode 4 of the 4 modes that the WTO talks. So, any insights into that aspect also?
See that I'm not expert of WTO, but still I what I see when I talk about the globalization. So I can throw some light on that. And what we see, WTO is an attempt for services sector, like the movement of everyone, goods, human being, resources, everybody has to freely move. So what we are happening, so when we teach globalization, we say globalization actually has happened for the goods. Human being is stopped everywhere. Human being has been not allowed to move freely. There are a lot of restrictions have been imposed. You can't easily go to the another country, education in the United States or the free movement. So WTO, in objective of WTO is deeper. It takes care of the everybody freely move. So trade move, people move for all this such. But what is happening? So with this ethos, with this philosophy, WTO has come into existence, and we started believing that movement of human being will also be facilitated effectively after WTO has come into existence. But when it comes to the movement of the human beings, what we see, there are a lot of conditions have been imposed. That is regulated with their bilateral, local conditions. A lot of factors are there, and there are a lot of conditions have been, barriers have been created. So human beings movement has been restricted. So WTO has failed. In that count, WTO has failed. And even having some kind of safeguards or some kind of regulations which is contrary to WTO principles. WTO it's some kind of there we see culture. Basically, it's the domination of the West and the European countries. So they are very close. Even those who are there to interpret WTO, they takes this note, their interpretation and their approach is entirely different, because they fear also, if we allow the way everything is moving, a human being, then people from Africa, people from the Other continent will come to our country, settle down, and other that will be problem is there. And that is the major problem which can be better understand when we look into the European Union. That is not so European Union. So admission in the European Union also. So in a small way, we can examine that question in the European Union context. So Turkey wanted to become member of the European Union for the many years, but various reasons it has been denied till date. Even for the refugees from Syria, they said, you take care of the refugees, we'll consider your membership. Turkey has done a lot of things, but it still has not been, because Europeans, they don't want like them come to Muslim population to come or something there are there. When the disintegration of the Soviet Union, so Bolivia, no, that's a small countries like Hungary, Poland, there's they moved to the democratic form of a government. There and former Yugoslavia. So when they one by one they become the member of the European Union, so a large number of countries from old, like France, Germany, Belgium, they oppose the entry of the East European countries also under the European Union membership because of the human member. They said, if they become the member, so entire Romanian people will come to France, entire Romanian population will come to UK. But in reality, it did not happen. So that fear was there, and because of that fear, they delayed the entire process of admitting new members from the East European countries in the European Union. Finally, they admitted. But the fear, so one point which we have to understand, nobody wants to live nationally or internationally their home country, the place they have been living. So given a chance, I always, so like in the place I am born, the place I have grown up, it always stays with me. It always stays with you. So human movement has proved wrong in case of the European Union also. So what is like WTO, if the states are feeling, everybody will come, that is not happening. That has not happened. And that is like a wrong perception. But they are very cautious, they are very alert, they don't want people to move freely, and that is the reason WTO has not also succeeded in a free movement of the human being, human resources. All right, Sridhar. Unmute yourself.
Thanks for the insights. It was useful.
Thank you.
I think there is no question now. So it seems that we have come to the end of the lecture series, this lecture. And on behalf of GRFDT, I would like to thank you for this constructive and engaging talk. So thank you very much, sir. And we look forward for future engagement with you. And I also thank all the participants to attend this talk. And I think now the session come to a close.
Okay, thank you very much, Smita, and thank you all of you for a wonderful evening. Thank you. All the best.
Thank you, everyone.